Enterprise Life versus ADOI. Council, you have instructions now that we're providing at the table, but with that, I think we're ready to begin.
Thank you, Your Honor. Good morning. May it please the court. My name is Paul Girding. I represent the appellants, Enterprise Life Insurance Company and National Foundation Life Insurance Company. I'm here today with co-counsel David Childers and counsel for the companies, Jim Jackson. To help frame the issues, I'd like to start a little out of the typical box by reading some testimony from the underlying hearing. This is the testimony of Aaron Klug, the Department of Insurance Assistant Director of Market Oversight Division. Ms. Klug testified, the fact that they, the companies, didn't file rates is not a violation of law. The department isn't being punitive here. The department is just merely trying to interpret the actions of the company and how the statute applies to it. We're not trying to punish the company by saying you have to leave the market for 5 years. That would not be the department's preference. We would much prefer that the company stay in the market, file their rates, and stay in the department. We think that's significant, Your Honors, because that helps to frame the issues that today's discussion is really narrowed given the department's position to 1380D, 2013-80D, and 2013-80E, pursuant to the Assistant Director's own testimony. That's at page 91 and 90 of the transcript. Additionally, 1380C is not an issue for Ms. Klug's testimony at page 59. We believe there, again, was no violation of law, and there's no punitive action or sanctions here. So looking at the plain meaning of 1380D, the question is it clear and unambiguous? We believe it is. All simply means all. The statute at 1380D states, if a healthcare insurer elects to discontinue offering all insurance in the individual market in this state, the healthcare insurer may discontinue that coverage only if the following occurs, and then there are several subparts. All includes renewals as far as the appellants are concerned. The department states no, all only relates to Affordable Care Act guarantee coverage. We think that's completely out of bounds given the plain meaning of the statute. Enterprise Life and National Foundation had ongoing grandfathered and transitional policies at the time of the failure to file rates or refusal to file rates relative to the Affordable Care Act plans. But the grandfathered and transitional plans were still in force. Those policies are still in force today. Those individual insureds still have benefits under those policies. Those benefits are being processed, and in no way has Enterprise Life or National Foundation, the appellants, withdrawn from the market constructively or otherwise. It's simply impossible to have withdrawn given their current status. They never elected to discontinue offering all health insurance coverage in the individual market. All renewed policies were in force, and all renewed policies are still in force. Appellants never withdrew, and to this date have not withdrawn a single enforced policy. The department's position tips the law to the breaking point through statutory gymnastics, trying to argue that all only applies to Affordable Care Act coverage or guaranteed policies that only came into existence.
Am I correct this statute was enacted before the Affordable Care Act?
Well, I was about to say that, Your Honor. You stole my thunder. That's exactly right. 10 years prior, this was a HIPAA-related act.
How could it be interpreted to apply to all ACA compliant or EHB policies if it was enacted long before that such a thing even existed?
That's exactly our position in our briefing, Your Honor. Again, under 1380D, all means all. It does not mean solely offering new coverage under 1380D, which is the department's position. And in looking at keeping the statutes in harmony, 1380B specifically carves out new coverage from the statute. So if you're looking at new coverage for 1380B, which relates to withdrawal for an individual's policy versus a total market withdrawal under 1380D, you can see there's a distinction between new coverage under 1380D for new policies and all coverage under 1380D. Therefore, the reading pursuant to the department would make 1380B superfluous.
But let's respond to that argument I just made, which is taking a slightly different interpretation of what the department's arguing is that all, in their case, refers to continuing to be offering new coverages under the market. So the ACA may have been enacted after this statute, but the statute still requires you to offer new coverages. Is that a fair reading of their argument?
New coverages,
Like to be a player in the market so that people could go on a portal today, but 5 years ago could call you up and say, hey, I'd like to buy new coverage. That would be really what they're arguing, right?
that would be what they're arguing, and we respectfully disagree. We're saying that all is a total market withdrawal. And the punitive action or the mandate under 1380E is for a total market withdrawal. If insurers were to try to get out of the market entirely, they don't want the legislature, parties coming in the market and out of the market pursuant to HIPAA. They wanted a continuation of coverage. So there was the 5-year mandate relative to a complete market withdrawal.
But here, I'm sorry, go ahead.
If an individual insurance company only offers, with regard to individual plans, only offers renewals, that is to say, there is no opportunity for new participants in this insurance company's policies, is that insurance company participating in any market?
Of course, it's participating to this date. It's offering that policy, those policies to those grandfathered insureds who have had insurance coverage for decades. It's offering that insurance.
I guess that's my point. They're not in the market for an insurance. They're not shopping. They have a policy and it's just a renewal. Is that, I'm trying to as I understand it, frame the state's argument, the market requires some participation of new individuals as opposed to simple renewals of.
The statute says offering all coverage. And we say offering includes, pursuant to the case law, an offer for acceptance. That includes renewals of traditional or grandfathered and transitional policies. It is not mandatory that the appellants stay in the market. So they could do a full 1380D withdrawal from the market, say we're out and we're not offering renewals or anything.
And in fact, that's the only way you could not offer renewals, correct?
Correct. We can.
And isn't that's why I'm getting confused, and I don't know if you saw our order, but what is the authority, as I read it, 1380D is intended, or 1380 total is intended to, and clearly explicitly says, you cannot cancel insurance coverages for people that you have unless you leave the market completely. Is that fair?
That's absolutely fair, Your
Okay.
Honor. And
How is that now, in your briefing, you seem to accept this as well, somehow give the DOI authority to tell you you have to cancel insurance coverages?
Well, that's exactly our point, Your Honor. The quote devastating effect that's cited by the Department of Insurance, there is no devastating effect.
But even if there were, where's the statutory authority in 1380 to tell them that, to give them the authority to tell you that you have to cancel insurance coverage?
We believe that there's none. There's no authority. It's a market withdrawal. If we withdraw, we withdraw. And if we're going to do a withdrawal, we can't do it partially. There must be a total withdrawal under 1380D unless you're doing a particular plan withdrawal under 1380C. But again, pursuant to the department's testimony, that's not at issue today.
Did the companies at any point in the administrative process or the litigation below explicitly challenge ADOI's authority to force the exit versus challenging their interpretation of the statute? In other words, is there somewhere that you can point to that the insurance companies said you don't have the authority to do this, not you're acting in contradiction to the statute, but an explicit the statute doesn't give
thank you, Your Honor.
this
It goes hand in hand. I
Okay.
mean, let's talk about the difference between a sanction and a mandate. A sanction would come under, say, 2220, where they have the authority to revoke a license given a violation of law. There's no violation of law in this case, so we'd say, with all due respect, 220 does not apply. And again, the department was not trying to take specific action against the insureds per Ms. Kluk's testimony. relative to, we want you out of the market because we're trying to protect the insureds. We're just doing this because it's ipso facto. The mandate says this must happen if there is a 1380D withdrawal pursuant to the way we read the statute. By asserting that 1380D was misconstrued, not by the ALJ, but by the Superior Court, we're stating that there should be no mandate. We did not violate 1380D. We maintained our position in the market. We continued to offer new policies, renewed transitional and grandfathered policies. We're still operating in that way today, so there never was a market withdrawal.
But you offered, I mean, you don't contest that you published rates, went into the portal where someone could have bought insurance coverages, EHB compliant insurance coverage from you.
Absolutely, Judge. We did so because under the CMS regulations of the deadline upcoming with regards to the Affordable Care Act, we had a duty at that time, we believe, to offer the Affordable Care Act policy or do a total market withdrawal. The decision of the appellants at that time was to offer the policy. Nobody took it for a period of 3 years.
If someone had bought it, you would be on the hook for renewing that for
We agree,
as
and I
long as.
believe we took that position in the underlying litigation.
So, counsel, looking at subsection D, when we have discontinue offering, that's modifying the word coverage. Is that accurate?
Correct. Offering coverage.
Coverage, okay. And if that's how we sort of begin the inquiry, then existing insureds certainly would fall under that point, which is they're covered, and for this to apply, you would have to discontinue offering coverage. It doesn't say offering new health insurance products or policies.
Correct. Your
It
Honor.
seems to focus or teeter on the word coverage. And if that's the case, does that help your argument or hurt your argument?
It certainly helps our argument, Your Honor, because the coverage would be renewed, it would be offered again. We're offering transitional and grandfathered policies. We did not offer new ACA coverage when the CMS extended the deadline now to 2021 because nobody took it. Nobody asked for it. If somebody actually accepted one of those policies, we would have a different position. We'd be in a different position.
So there's no term of art in the insurance world that coverage means new bells and whistle policies to new customers, but excludes the existing customer base.
No, Your Honor, there's no such rule. Offering coverage is to offer coverage. If, for example, to offer, as the case law states, uninsured motorist coverage, you need to make the offer. You make it available to someone to accept. And again, this wasn't a mandatory issue. You always had the opportunity to say, we're not going to offer coverage anymore. Many companies pulled out of the market completely. Appellants determined instead to protect their insureds, those people who still have policies, have been covered for years, and the true devastating...
It's what, 28 or 29? Is that the right number of people?
Correct, Your Honor.
Okay.
And if those people are thrown out of the market, the true devastating effect here is on those insureds, because there's nobody that is covered by the Affordable Care Act policies that were once offered by the appellants, because nobody wanted them. Nobody purchased them. And once there was nothing to offer, there was no need for it, there was no offer. The only thing to offer was the continuing coverage for the renewal policies. And with all due respect, that goes to 1380C. We certainly had no notice requirements because there was nobody to notify the director about with regards to coverage because simply no coverage applied.
But even then, even if 1380C was invoked, it would give the director authority to force you to offer that coverage, not to necessarily terminate the coverages that you already have.
If there were particular plan in-force policies that the
I mean, it says
company-
the health and care assured may discontinue that policy form only if. So if you don't meet those requirements, you have to offer that policy form going forward, right?
As long as there are insureds in force. The first issue is, Your Honor, before the health insurer gives notice to each individual covered, that entire statute contemplates that people are covered by a particular plan that's being withdrawn.
I'll respectfully disagree. I mean, it says offering a particular policy form offered in that market. Doesn't necessarily say one that someone's bought. It's saying a policy form that you're offering. So, but I think I'm helping you here, not hurting you. So
Yes, you
probably
are.
you shouldn't fight with me too much on this one.
Try not.
But it would say that there's nothing here that would say you have to now terminate the coverage for your 29 existing insureds. If anything, it would say they could tell you you've got to offer this policy form
Correct. Your
going
Honor.
forward.
Correct. And again, 1380C was not the issue that was tried before the court. In fact, Ms. Klug repeatedly testified at the hearing that 1380C did not apply. I'm going to save 5 minutes for rebuttal.
Thank you.
Thank you, counsel.
Good morning, and may it please the court. My name is Lynette Evans, Assistant Attorney General, here today on behalf of the Department of Insurance. Your Honor, before I jump into my argument, I'd like to go ahead and address the issue that was posed by this court in the order issued last week. And of course, that is the enforceability and who has the authority to enforce under 20-1380 subsection D and E. The legislature has granted the department, and specifically the director, broad authority over all Title 20 statutes. Specifically, if we look at ARS section 20-142, subsection A, it provides that, quote, the director shall enforce the provisions of the title, close quote. But even more importantly, if we drop down to the next subsection of that statute, that's subsection B, it provides that, quote, the director shall have powers and authority expressly conferred by or reasonably implied from the provisions of this title, end quote. So the authority to take the actions described in 20-1380 subsection D and E is reasonably implied from the law. To be honest and to be direct, Your Honors, if the department doesn't have the authority to enforce the statute, then the statute is unenforceable.
I don't think our question was whether you have the authority to enforce the statute. I don't think anybody argues you have the authority to enforce Title 20. The question was, where is the authority, and tell me where it's reasonably implied that you have the authority to enforce a statute which is designed to protect people from having their insurance canceled. You would agree with that, right?
I would agree, Your Honor.
You have now interpreted that, saying that that gives us, reasonably implies the authority to force a company who wants to continue offering coverage to cancel that coverage. So where's the reasonable implication that we can rely on?
Sure, Your Honor. I think the purpose of the law is to create, to be quite frank, a deterrent for insurance companies making decisions about what types of products they're going to offer.
No, I think it's intended to provide a deterrent from them canceling coverage, which you just agreed with me on a second ago.
That's correct.
Okay, so where's the reasonable implication from that?
Right. So if we eliminate the department's ability to enforce that deterrent, then there would be
No, if they cancel coverage, you can suspend them for 5 years. So that's the deterrent. What? I'm sorry, I'm being overly argumentative, and I don't mean to be, because I'm very confused by all of this, and so I get perplexed. So I'll let you talk.
Sure. No, fair enough, Your Honor. And I think the way the statute is written, it really lays out a process for an insurer to follow so that they can exit the market in a way that is less disruptive for the existing policyholders. But if they make that choice, that first election to not offer new policies in the market, I think you mentioned earlier, there is a process where if you are a participating member of this marketplace, then you have to offer both new as well as renewal, that there is a trade-off for entering into the market and participating. And that is not only just renewing existing policies, but also offering new policies. And so again, in order to enforce that provision, to make sure that a policy or an insurer is not just renewing existing policies and not really participating in the market, there has to be this other option that exists so that they would have to withdraw entirely from the market.
And
so-
what words are you relying on specifically in the statute for that guaranteed binary, offering?
Sure. So I think just by way of background, and I know that some of this was covered in the briefings, but the HIPAA was enacted in 1996. Arizona adopted those provisions in our statutes 1379 and 1380. Obviously, the ACA came along, it expanded the eligibility for coverage, and then obviously the requirements here in Arizona.
But there were no amendments made to 1379 or 1380 to update it to reflect ACA, right?
That's correct. There have been no amendments. So basically,
So you're looking at, I got the statute right in front of me.
Sure.
So we can go right, work on the same topic. What words in this statute do you rely upon for the notion that offering all health insurance coverage means what, I guess, ADOA has interpreted it to mean?
I would direct the court specifically to subsection D, and so we would start with the beginning of the statute. If a healthcare insurer elects to discontinue offering all health insurance coverage in the individual market, and then the insurer may discontinue that coverage only
So
if all
let's
the following.
take that sentence fragment. Would you agree with me that discontinuing existing coverage, an existing otherwise renewable possibly customer, would be would qualify for that part of that sentence, would be discontinuing offer of all health insurance coverage?
I would say it could be a part of the offering. It's a little, there's some more clarification when you look at subsection 3, because it talks about if the insurer discontinues all individual health insurance coverage that was issued or delivered and does not renew. So that goes to the point that was raised by Enterprise, which is that somehow offer includes or can be just limited to renewal. Clearly, the legislature specifically referenced renewal separately, right? So if there would be no reason for them to have listed renewal separately if discontinuing all coverage would have applied to the renewals as well.
But subsection 3 doesn't seem to line up against one another, offer and renew. It's issued or delivered and not renew. Offered seems to be something that encompasses all of those things.
I think if you look at the other parts of the statute, so for example, I mentioned that both statutes were enacted together, 1379 and 1380. If we look at 1379 subsection T, there's some guidance on that word offered. Specifically, the statute talks about this section, and I'm reading quote, subsection T, this section and sections 20-1380 apply to all health insurance coverage that is offered, sold, issued, renewed, in effect, or operated in the individual market after June 30th, 1997, regardless of when a period of creditable coverage occurs. If we drill down on those 4 words, offered, sold, issued, renewed, we can see that the legislature clearly distinguished between those 4 specific acts. They were not combined together. They were not saying that offer was the same as renewed. So clearly there's a distinction in the law that would apply broadly to 1380 as well.
I want to go back to your reasonable implication argument, which obviously I'm very fascinated by. And let me pose a situation. I would have more sympathy or more, it would carry more weight with me if you were arguing that this statute gives us the authority to order them to offer EHB plans like they did from 15 to 17. I'm having a hard time saying that a statute designed to keep them from terminating insurance coverage gives you the authority to order them to terminate coverage. Do you see where if you were coming to me and saying they have to get back in the ACA market, and we've got that authority, it's a combination of 2142B and 1380 to tell them they have to continue offering that coverage, I think I'd probably be sitting here going thumbs up. But you're saying, no, they have to terminate coverage, and my authority for that is a statute telling them they can't terminate coverage.
Right, so in this particular context, it's the process. So let's see if I figure out a good way to say this. The insurer still gets to make the choice, right? We can't force them to sell policies here in Arizona. And that's what the legislature was
But you're framing it in the choice. They have a choice.
They do have a choice. They
And
elected.
your question is the choice to continue offering policies or not continuing offering policies, right?
That is the choice.
And they're continuing to offer those policies to their existing customers.
They do have grandfathered and transitional policies that are continuing to be in effect. But the choice is whether or not they want to offer new policies. And the legislature gave them that option. There is no requirement that any insurer that jumps into the ACA market continue to offer new coverage. They can elect to not offer new coverage, but the consequence of that choice is that then they have to pull out of the market entirely. So I would say that was
But wouldn't you say the consequence of that choice is ADOI forcing them to cancel a whole series of policies, i.e. the grandfathered and transitional policies, which is literally the opposite of what the statute is supposed to do.
I think that the statute was intended to create a healthy insurance market, to make sure that we have both guaranteed
I think
availability.
the statute was created, as we discussed at the beginning, to protect individual insurers from having their policies canceled.
It was to protect.
That makes for a healthy market, that makes for a predictable market, but this statute is about protecting individual insurers from having their insurance canceled, which is the result of the ADOI decision in this case. And I think that's the part that's just, there's a disconnect here from what the legislature was seeking and what ADOI is seeking. At least that's what it seems like.
There is a protection element for consumers, and certainly, as you see in the statute, it lays out a very orderly process if you're going to withdraw from the market, if you're going to discontinue policies. But there's also a protective effect for the entire insurance market here in our state.
What's your authority for that?
Right, and I would go back to 20-142, subsection A and B, that does give the department broad authority over all Title
Well, you just
20.
said no. You said the purpose of the statute is to create a market for the entire state. What's the authority for that proposition?
I would direct this court
Because
to...
I looked at the Senate fact sheet for this statute, 1380, when it was enacted in 79, and it said the purpose of the statute is to provide guaranteed renewability for all individual health insurance coverage.
Well, and what's the name of this statute? Guaranteed renewability of insurance health coverage.
Correct.
Okay.
Right, and 1379 is guaranteed availability. So I do think these are two components that have to work together.
But I want to know what the authority is that this is a market-based, not an individual-based coverage, because that's what it boils down to. Is this protecting individuals or is this protecting the market? And I don't see any authority for this concept that it's protecting the market. I agree in the ACA world, we need incentives for people to enter the portals and enter the market. But how are we getting this statute to provide that?
Right, so I don't know if there's a specific language in 1379 or 1380, but it's again...
But that's what you relied on, is 1379, 1380.
That's correct, Your Honor. As well as, again, as the court had asked, really just the broad authority of the department to enforce the insurance laws here in our state, to make sure that the insurance market here is functioning as effectively as it can be. So, Your Honors, Enterprise is asking this court to allow it to have the benefits of participating in the ACA marketplace without bearing the responsibilities that go along with those benefits.
But it's not trying to participate in the ACA marketplace. It's providing in policies that are transition and therefore exempt from the ACA requirements.
Right, but those policies are going to be coupled with this ACA marketplace. So because they...
What does that mean? I don't
Because
follow.
they entered into the ACA marketplace, then they were subject...
But no
to
one
those-
bought, so they don't
That's
have any
correct.
existing policies we're canceling in that pace.
Right, but their ability to offer those transitional grandfather policies is tied to their initial participation in the ACA marketplace. So I would say that the law requires that they not just sell insurance, right, that they not just renew existing coverage, but that they offer new. And basically, the guaranteed renewability and guaranteed availability are fundamental and critical elements of the healthy insurance market. It's critical that they be required to provide both of those, that they work in conjunction. I think it's helpful if you look at the structure and overall organization.
Legislature could have easily written a statute that said, once you enter the market, you got to stay in the market, right?
Sure.
Okay.
But instead, they said, once you enter the market, if you
No,
make,
they said if you want to cancel coverages, you have to exit the market.
and if you take these steps, if you make these choices, then there are consequences for those
They didn't
choices.
take those steps. You're trying to order them to take those other three steps.
Right.
They
took-
may have taken one, and that's part of the debate, but there's no dispute that they did 1, 2, and 3, so you're trying to order them to do 2 and 3.
Right, because the department believes that that's what the statute requires. They took, like you said, we all agree, they took the initial step. They made the choice.
Well,
to-
I don't think we all agree. There's a question of whether it's all or some or coverage renewals, but
Sorry, when I say all, I meant in a different way. I think we would agree that they took the step, they made the choice to not offer new policies here in Arizona. If you look at the structure of the law itself, it's helpful to break it down by sections, right? So if we look at Section B, that describes the circumstances under which an insurer may non-renew or discontinue coverage of an individual member, right? So one single policy holder. If we go to Section C, that has the requirements for insurers that have discontinued offering one of their guaranteed available plans. So, for example, if you have an insurer that offers multiple plans, and say they have a gold plan, a silver plan, and a bronze plan, subsection C is the process that an insurer would follow if they choose to discontinue one of those guaranteed available plans.
isn't that what this is? They elected to discontinue offering the EHB plans, you guys could have invoked C and said, you've got to continue offering these EHB plans. You
Right.
didn't meet the requirements.
So I would disagree. I believe subsection C applies to types of plans. Like I said, a gold plan, a silver plan, or
Well,
a bronze plan. Those are not, subsection D is triggered if you choose to discontinue all of your guaranteed available plans, all of the new policies, whereas, again, C.
It says offering a particular policy form. You keep changing the phrasing in statutes, which I always get confused by. So let's stick with the actual statutory language.
Right,
It says particular policy form.
correct.
EHB plans were a particular policy form.
Form refers to different types of plans from the way the department looks at it. And that's why we said at the hearing, and certainly.
Was it a particular policy form offered in the individual market?
It was, however, subsection D is what really gets triggered because now they're no longer offering any of their guaranteed.
Could you
available
have said
plans.
under subsection C, regardless of whether, maybe you have an argument on D, but could you under subsection C have said, you guys elected to discontinue offering these EHB plans. That's a particular policy form. You have not met these requirements. You have to go back and reissue.
We would have said C applied if Enterprise had offered multiple guaranteed available plans, different types of forms, and had chosen to discontinue one of those forms. In this case, though, they are saying they no longer want to offer any new policies here in our state. And that's why I believe
So
section
you would
D.
read C as narrowing your authority and D as granting you almost unbounded authority.
I wouldn't say unbounded, but I do think C applies to a particular set of circumstances that does not apply in this particular situation.
Fair enough.
So back to the facts here in our case, from 2015 to 2017, Enterprise offered both
Let me ask
new-
you one question,
Yes,
Counsel.
Your Honor.
Sorry to interrupt you. So you had made a statement earlier about if the court doesn't hold a certain way, we'll have no authority to enforce the statute. Now, what does that mean, enforce the statute? Might it mean that an insurance company has taken the steps to exit the market under the ADOI's definition, and they neglected to do one of those winding up parts, like pick up the phone to call the director, and the ADOI, couldn't that be enforcing the statute for ADOI to issue an order saying, insurance company, you have not followed the letter of the law, which required you to provide this amount of notice to customers, and this, isn't that also ADOI enforcing this statute? And that would remain intact, right?
Right, so I do think, based on what you were describing, is there could be a requirement, the department could issue an order or a directive to a company that says, pursuant to the statute, you have to take X, Y, and Z step, and you've failed to do that. We believe that's what's occurring here, right, where they did not take one of the steps required in the statute, and the department was notifying the company and requiring that they comply with the law following that initial decision to not offer new policies here in our state. So in this particular set of circumstances, too, it's helpful to note that there have been other insurers who have made the same decision as Enterprise, and all those insurers did discontinue their existing policies. They also adhere to the 5-year prohibition from selling policies here in Arizona. You know, I think the
They
important,
do
Has
that
any other-
voluntarily, or when the ADOI made them do that?
from best of my knowledge, I believe that was all voluntary. In fact, before this case,
So they voluntarily exited the market.
They did follow the process laid out in the statutes, right? They stopped offering new policies, and then
They wanted to not have to renew their existing coverages, so they left the market and followed the procedures.
They followed the procedures. I'm not sure what the
And
particular
these
motivations.
people want to continue their existing coverages.
Yes, Enterprise would like to continue to offer its transitional and grandfathered policies, and we believe that that's, like I said, inconsistent with the requirement of guaranteed availability.
Am I correct in reading the briefing and some research in that only Colorado, of the 8 states with similar statutes, only Colorado's kind of followed the approach that you have suggested, and the other 7 states have pretty soundly rejected it?
Right, there have been other states that have looked at this issue differently. I believe there might be more than one state that it has also had similar view to the state of Arizona. That's not in the briefings or in the record. It wasn't available.
Other
at the
courts aren't
time.
as good as ours anyway, so why would we follow them?
But yes, I believe, other states have looked at this differently. I will say, just to clarify that, the actions of other states is certainly something to look at, but it's not entirely helpful just because here, the way insurance
There's some
is
differences
regulated.
in statutory language.
There's some
too, so-
differences, but even beyond that, insurance is regulated on a state-by-state basis, right? And each insurance director for their state is responsible for the market, for the health of their own market. And so the decisions that we're making here in Arizona really are reflective of what we're seeing in the market and what we believe will lead to the market health in our particular state. I just want to make one other final point before I sit down, Your Honors. This case is about more than just Enterprise. Enterprise, of course, is just one company offering a relatively small number of policies here in our state. But the department does have a bigger concern, and that's the entire individual health insurance market in our state. If this court were to adopt Enterprise's arguments, then other companies, larger companies, companies that sell more policies here in Arizona, that touch more Arizona consumers, could make the same decision and leave the new insurance market without facing any penalties whatsoever.
How so?
According to the arguments laid out by Enterprise, there would be no process for the department to force those companies, right, to withdraw entirely. There would be no penalty, no deterrent. And so that could have very serious repercussions for the entire market. Lots of other companies could make that same decision, leaving some counties perhaps even without coverage entirely, without any options for consumers. Department's interpretation is consistent with the law, with the rules of statutory interpretation, and the purpose of the law. And consequently, we would ask that it be upheld. Thank you.
Thank you.
counsel.
Well, Your Honor, just to follow up, with regards to the briefing inquiry, I believe it is just Colorado and Arizona that have taken this position. There were 7 of 9 states that have addressed the statute. 7 were rejected the ADOI's position. Arizona and Colorado are the 2 holdouts that we're aware of, and that's what was in the briefing. Essentially, Judge, the appellants want to continue to guarantee the renewal of their transitional and grandfathered insurance policies. And isn't that exactly what 1380 is supposed to guarantee? We're here today trying to fight for our ability to continue to represent those insureds. I did hear Ms. Evans say that there's no requirement by the legislature to offer ACA policies. There's nothing, therefore, reasonably implied in the statute that would give them the authority under 2142 to start mandating that these policies be offered. They've couched this in terms of constructive withdrawal. In reality, we viewed it as compulsory advancement, and that may be a laudable enterprise. However, it just doesn't have statutory authority. If they're seeking to force insurers to provide ACA coverage, then go to the legislature and make that happen. It will ultimately happen.
Or if they want to force insurers who tried to stay in the market or risk a 5-year ban, that could also be something the legislature would do.
Yes, Your Honor, absolutely. And just because this insurer and these insurers have decided to protect their insureds and want to stay in the marketplace doesn't mean that we should go again through these statutory gymnastics that will force them out because of this compulsory advancement agenda that they're trying to press, which they've admitted there is no source of within the legislature or within the statutes to provide for that type of action.
We
That
talked
it
about
can't
the
even be
precedent.
reasonably implied.
We talked about the precedent from the 7 other states. It seems like there's kind of a precedent on the department side from the other insurers who've exited the market and canceled the coverage. Why isn't that compelling to us? That
Well,
everyone else who's looked at this in the Arizona market, looking at the Arizona statutes, has seemed to think that they have to take the 5-year ban and cancel their existing coverages if they're not offering ACA policies going forward.
with all due respect, what I heard was that was allegedly something that was chosen by those insurers. We want out of the market altogether. We're not going to mess with it. We're not taking into account those insurers that are ACA.
But they didn't even try and keep their existing coverages.
That was their business choice. However, there are also insurers in the marketplace today in Arizona who provide ACA coverage. That's a choice that we can also make. That was something that we offered rates for. Unfortunately, nobody took it. Again, at the end of the day, this may all be moot because the CMS may come down and say after 2021, that's it. You must offer this coverage. If
I thought that
Arizona-
there was isn't there a difference between grandfathered and transitioned policies?
Yes, Your Honor.
Okay, so grandfathered, I think doesn't the ACA say you get to keep offering those forever?
Absolutely, Judge.
Okay, so
Transitional
the
policies.
CMS will only affect the transitional.
Transitional policies or the offering of new coverage. Or if the legislature wants to, the legislature could say, Arizona's going to get ahead of CMS, and we're going to mandate Affordable Care Act coverage. But again, that's an issue for the statute, that's an issue for the legislature. That is not within the ambit of statutory authority before the court today. Again, Your Honor, we're respectfully saying, if that's something that they believe is essential to the marketplace, don't punish the insureds who have coverage by throwing us out of the market. Go back to the legislature and ask them to promulgate rules that would make that clear. Again, taking a guaranteed renewability 1380 statute and trying to turn it into from a HIPAA pre-ACA statute to a compulsory advancement into the market under the ACA without any amendments is just too far of a stretch. And under the statutes that were just cited, particularly 2142, how could you reasonably apply something that's just not there in the statute? I will say, Your Honor, with all due respect, we did get the order. We did an exhaustive search throughout the statutes. We did look at 220. That's a sanction statute. Again, there's no sanction here. It's a mandate. And the difference between a sanction and a mandate is significant. If the insurers here were forced to withdraw from the marketplace under 1380, they just leave the market. If, however, Section 2220 applies, or they're taking action under 2142, the appellants would maintain that would be a reportable event as a sanction for a violation of law that would have to be reported to every other state and could affect their business in every other state. So there's a very clear distinction here. We say stick to the department's own position that this was a clear just operation of law 1380 to 1380D.
I didn't hear them invoke 220 as a basis for their authority.
With all due respect, Your Honor, you asked us to look at anything that could possibly be
I'm just want to make sure, because I heard her cite to 142 A and B. I didn't hear 220 today.
2220 relates to the authority for if the department finds there's a violation of the title, then they may revoke certification or invoke certain penalties. Typically, that's a 1-year revocation. There's no reference to 5 years, and we're saying, as the department itself has admitted, that there was no violation of law, 2220 shouldn't apply, but respectfully, the court asked us to look at the issue, and we raised it.
Thank you.
Thank you, Judge.
Thank you very much, both of you, for your informative arguments, and we will take it under advisement at this time. We are adjourned.